All right. Welcome everybody to Nexus monthly webinar. I'm excited to have a couple of great people on today to talk about some current legislation and rent evictions and some of those current topics. I thought I would start out by giving you guys a quick update on what we're seeing in the marketplace as brokers. Again, Nexus Commercial Realty, apartment brokers, and land development brokers. Some interesting stats just from our company. We did more listing presentations, was what we call them, but BOVs or opinion of value in June than we've ever done before. I think that attributes to what people are trying to figure out where values going. Are they holding steady? Are they going down? Are they potentially still going up? So that was a fun month, and that's led to us having now 27 deals under contract. So that's up significantly than 60 days ago. And we are very, very close to being essentially back to what we were under contract for before COVID. So that came a lot faster than I think we were even expecting. And it seems around town and looking at the market on the brokerage side that it's definitely picking back up from all sides. So thank you for joining. Some of the things that I think that are driving our market right now, debt is very cheap. Collections are still good. Rent growth is down. If you talk to some people, I mean, there seems to be a lot of activity on the rental side, but not as much rent growth or straight rent growth. Our biggest challenges on the, hold on. Biggest challenges right now are honestly accessing units and doing inspections and getting appraisers in properties is one of probably our largest challenge to date. So with that, I want to turn it over and let our two speakers talk a little bit, introduce themselves and their organizations. Drew, you want to start that off?
I'm glad to. So I'm Drew Hamrick. I'm General Counsel to the Colorado Apartment Association. I head up the government affairs group for that organization, and that function is primarily a lobbying effort. You know, there's a lot of bad ideas being bounced around at the State House, so it is a growth industry, and we're delighted to be here with you today. I've got a couple of slide decks I wanted to share with the group, and the first one I'll tee up. Give me just a second to pick the right one here. So I hope this will be of some interest to the group. And will someone verify that I've got a good screen showing of this?
Cannot see it.
All right, hold on just a second. How about that? Did that give me what I wanted?
Got it.
Okay. So from the housing advocates out there, we're just being deluged with this claim of an eviction crisis. You know, that started off with the initial shutdown starting in late March, and they were predicting a crisis in April, and when we showed them there wasn't one, they moved it to May and then to June and to July, and the latest version of this is the crisis is going to come in September. So I've put together a deck that I'm using with policymakers and a lot of media inquiries on this, and I thought it might be of interest to this group. The first thing that I try to show people is that the eviction levels over time are very, very constant. What I've plotted here is total eviction numbers throughout the state from 2001 to 2019. And there's a couple of big things you can glean from this. The first, which is kind of interesting, is there were 38,000 evictions in 2001, and there were 38,000 evictions in 2019. Now, that's against a backdrop of a population growth of 1.2 million people. So in reality, per person, the rate of evictions have been falling fairly dramatically for some time. But when you're just talking about overall raw numbers, there's been a slight decline over time, but that curve is very, very flat. There's no such thing as a year with less than 36,000 evictions. That's just the amount of friction in the market. And at the very worst of times from an eviction standpoint, they've peaked at 50,200. So it's just not an event that has wild swings in activity. The next thing I try to show people is how strong collections have been since the various government mandated shutdowns started. What I've plotted here is rent by month. So you've got a cluster of April, May, June, and July there. Colorado numbers for 2020 are in blue. We've laid out 2019 for those months just to give people an understanding of normality. And then we've plotted the national levels again for 2020 in gray here and for 2019 in orange. So the first thing that jumps out at anybody looking at this is there's no catastrophe here. We're talking about collection rates in the mid to high 90s throughout. These are all done as the 20th of the month. I know we'd get stronger data if we'd show end of the month collection rates, but people are clamoring for these numbers mid-month, and the 20th seems to be kind of the cutoff date for most management companies of when they've got a serious delinquency or just fluctuating delinquency. But no catastrophe here is the overall message. But there's some other trends you can pick up on this too. One, you see that Colorado is consistently several points better than the national average. That's just a reflection of Colorado's stronger economy in general and a stronger housing market in particular. You can also see that to the extent there's been a trend, things improved from April to May, and again from May to June. A little bit of, on the national level anyway, a little bit of a slide in July, but again, nothing dramatic. And all is good in the collection world, which of course, you know, the majority of evictions are based on non-payment of rent. So that's what drives eviction levels. On the advocate side, their general argument is unemployment rates are very high, housing costs are very high. So if you take the eviction levels before those increases and extrapolate from them, you're going to get this massive number of eviction. The number they typically throw around is somewhere between 460 and 500,000 evictions. And so what we've done here is just simply plot historic unemployment rates against that relatively flat eviction level. And a couple of really interesting things pop out. One is at the overall peak in evictions back in 2007, and again, we're looking at an eviction rate of about 50,200 annually. Unemployment was all the way down at 3.6%. Likewise, when unemployment peaked at 8.7% in 2010, evictions were falling and at a relatively normal level of 40,000 for that year. And then as the unemployment rate has continued to bottom out over the last few years, evictions have stayed steady and gone down slightly. So there's no correlation. You're not seeing these two numbers track at all. So any prediction that just says, well, unemployment rate was 2.7% before the government shutdowns and is now 10.2%, you can't multiply the evictions and extrapolate from that. And the same relationship holds true of rent rates when someone tries to argue that because housing costs are high in Colorado, which they are, you know, we, after 1.2 million people being dropped on us over this course of time, but more importantly, about 500,000 in the last 6 years, construction just hasn't kept up. And you've seen really steep rises in this period between 2013 and 2016. But overall, that rent growth rate is about 2.2%, not much more than inflation. And you see evictions have not increased at all with increases in rent. I always try to make people that are not landlords understand that the eviction process takes between 2 and 3 months, because there's this belief that the landlord files an eviction action and people are evicted. And so I give them a timeline on this. You know, everybody's rent's due, or not everybody, but virtually, on the 1st. Most leases have a 4-day grace period. Under current law, once that expires, if you're going to start the process, you've got to give a 30-day demand for rent or possession. After those 34 days, you can file an eviction action. By statute, you've got to give the resident between 8 and 10 days to answer. If they do answer, the trial is 7 days later. When you win the trial, there's a 2-day stay of execution. And then the real variances kick in, which are based on which county you're in. Sheriffs differ in their amount of backlog. In the fastest counties, you know, you're dealing with about a 10-day backlog. In the slowest, you're dealing with a month and a half. And so that gives you a total eviction time between 61 days and 98 days. So that has a couple of important effects. One is that since that process is so long, the vast majority of filed evictions end up resolving themselves before the sheriff comes out and makes someone move. You know, one of two things happen. Either the resident's able to dig up enough money to cure the late payment, or alternative, the resident's able to find a new place to live and moves out. But of those 36,000 on the low end evictions that are filed each year, only about 17% of those end up with the sheriff coming out. You know, a full 83% get resolved some other way. The other thing that's important is when people don't understand how much money a landlord is losing on an eviction, this helps them grasp that, because you can't take rent while you're evicting unless it's, of course, full settlement. And if it's a 3-month process and average rent is $1,400, well, that's $4,200 in lost rent plus hard cost of about $1,000. So this helps non-landlords, I think, get their head around what they ought to know, which is that you can't make any money on an empty unit, but that an eviction cost you $5,000, and therefore you're not trying to generate these. This may not be my best graph ever, but what I'm trying to show people here is just how much evictions have dropped off. So at that high rate of 50,000 evictions a year, you'd expect to see 12,550 evictions filed in a 3-month period. At that lowest rate, at 36,000 evictions a year, you'd expect to see 9,120 evictions filed in 3 months. What was actually filed in May, June, and July were 90 evictions. So to the extent there's any abnormality in that period of time, the only abnormality is that nobody's evicting anybody. We got some preliminary numbers thanks to VIX Group. There, as of July 21st, I believe it was, there'd been just under 200 evictions filed statewide. So remember, the moratorium ended in June 13th. So even without a legal moratorium on evictions, you're just not seeing a flood of these civil actions being filed. I don't think I have to go through that one with you guys. I think another thing that's important to remind policymakers of in the media is just how small most landlords are. Now, there's not great data out there on how many units are owned by each landlord, but you can get kind of there by breaking down the size of rental properties. And over on the right side are the largest properties, those over 100 units, and those make up 8% of the rental properties. 50 to 99 units make up 3%, 21 to 49 units make up 7%, 11 to 20 units make up 8%, and 8 to 10 make up 3%. The largest segment by property is this 2 to 7 unit segment that makes up a full 56% of the market. And the only number on here that's I question its accuracy is this single family home component. And that's because you can't get to whether it's a rental property by property records. You have to get this from self-reporting of landlords. And 15% of the market are self-reporting single family landlords. So this number could be higher. It could be just a single family home and we don't know that it's being rented out, but it could not be lower. So this is an absolute floor. So for the purpose of my argument, which is, hey, most landlords are not big operators, we can safely say that more than 70% of the rental properties in this state are units of 7 or less. And it's important for two big reasons. Obviously, if you're renting out one unit, you don't have the benefit of diversity. So when I tell you there's a 95% collection rate, if your one tenant isn't paying you, you still have a 100% delinquency rate. And then these folks aren't either capitalized or sophisticated to the point that they're any better to weather a government shutdown storm than are the residents that are actually renting the units. So with all that, the message we're pushing on our end is Colorado's not experiencing a crisis and an inability to pay rent. There is not an eviction crisis. Anybody that's predicting that there'll be 500,000 evictions, that's a tenfold exaggeration. And frankly, I think everybody on this call understands that the way a free market works is you never have 500,000 Coloradoans living in a park while 500,000 apartments empty. That rent tends to fall until equilibrium is established. But there are people on the other side of the aisle that don't instinctively get that. And the overall message that we have to push again and again and again is what we're ultimately trying to do here is encourage one person to loan a piece of property to another person. And the only way you can do that is if you have a mechanism to get it back that's reasonably priced, reasonable in a length of time, and reasonably predictable. And as soon as you break that system, nobody's going to loan anybody a piece of property. They'll just sell fee simple title to it, and that will be the only way to acquire. So I'll pause there. I don't know if that generated any questions that we can respond to, but I can let Vic kind of go through his legislative slides.
Drew, I had a quick question for you, or more of a comment. Can you talk about, for the people that are not part of the apartment association, just the things that you guys do for education and then also down on Capitol Hill that are very beneficial to apartment owners?
Well, absolutely. Those are two of the association's biggest functions. The Government Affairs Department is the lobbying arm, and we engage with the legislature and have employed third-party lobbyists for that purposes. My role is message development and serve as a witness and a spokesperson when necessary. But if you're motivated to try to fight some of the annual bad ideas that come up in the State House, ours is the organization that's been formed to do just that, and it's the most efficient way for you to channel dollars into those efforts. We're also affiliated with the National Apartment Association, which some of you may be familiar with, who does the exact same thing on a federal level and engaging on the federal eviction moratorium and the CARES Act and those types of things. We also have a very extensive education department. We publish the Colorado Legal Handbook and a number of form leases, and we conduct constant classes on everything from how to maintain a garbage disposal or a swimming pool to how to comply with the latest new legislation coming down the park. So I think our membership is a very good value to a landlord. I would suspect a lot of you on the call are likely members already, but if you're not, I'd certainly suggest you engage. Julie Evans-Schmidt is our membership director, and I'd be delighted to put you in touch with her because we're not turning landlords away down here.
Perfect. We do have one question, Drew. Is there a current federal moratorium preventing Colorado apartment owners with Fannie or Freddie loans from posting evictions until July 27th?
Briefly, yes, there is. Vic's got a whole section of that in his slide, so I don't want to step on his toes, but yes, there is, and a detailed explanation is coming.
Perfect. Let me get this up shortly.
I can see that.
Can you see
Adam.
that?
Yeah, I'm good. Drew, can you see that?
Yes, it looks great.
Okay, great. And Drew, I know you were intimately involved with the in dealing with the new statute. So as I'm going through, please feel free to chime in. You probably have a lot more knowledge at this point than I do, so you will not be stepping on my toes. Good morning, everyone. I'm Victor Solzer. I'm with the firm Cheddar Solzer. We're the largest landlord law firm in the state. We've been around about 30 years. We are full service to landlords and property management companies. We provide services for pretty much everything that comes up with ownership and management of your rental properties, whether it's doing leases, evictions, dealing with fair housing situations, small claims, dealing with vendors, literally everything that you have to deal with in owning and managing your properties. About the only thing we wouldn't handle, although we could, would be personal injury situations. Those are going to go through your insurer, but we deal with everything under the sun. Hear a lot of interesting stories every day. So good to talk to you all this morning. We're going to go through the legal update for this year's legislative session. So we'll talk about Colorado laws, the governor's executive orders, and the Federal CARES Act. Since the CARES Act was signed March 24th or whatever the date was, it almost seems like every other day there was a change to the law or an interpretation. Then you had the governor's executive orders that we had to analyze, and it's really been just kind of a nightmare dealing with all this, because our legislative framework for evictions and other issues has been fairly straightforward, and in the last 3 to 4 months it's really just kind of gotten very confusing. So the first new law that we'll talk about is the source of income law. This passed just recently. Up until the law was signed, you were, as a landlord, were not required to accept vouchers from a housing authority, also known as Section 8 or housing choice vouchers. There were 2 exceptions. City of Boulder and City and County of Denver, within the last couple of years, passed ordinances requiring landlords to accept Section 8. But if you were not in Denver or Boulder, you were not required to accept vouchers. That all changes now as of the enactment of the law. The law will go into effect January 1st, 2021. So we can go to the next slide, Adam. So there's no more refusing tenants just because they are on Section 8, as I said, effective January 1st, 2020. And what this does, it protects the landlord, or excuse me, protects the tenant and requires the landlord to accept any lawful and verified source of money paid directly or indirectly. So we can go to the next slide, Adam. Sorry, I keep saying Jason. Okay. Well, actually, if you could back up one, I've got a few more notes on the source of income. So a source of income would be any income derived from any lawful profession or occupation. income or rental payments derived from any government or private assistance, grant, or loan program. So you are not going to be able to refuse to rent to a tenant based on a source of income alone. So it's going to be, we're going to have a lot of issues where tenants are going to say, well, I'm getting a loan from so-and-so, or I've got money coming in from this source. There's going to be a lot of issues that have to be analyzed come the first of the year, because depending on where the tenant's money is coming from, you may not be able to deny their application as we were able to in the past. 100% if they have a voucher, you are going to have to take that. We're not overly concerned about this issue, at least on the voucher front. We don't think that there's going to be a flood of applicants with vouchers because there simply aren't that many vouchers available. But we could get a lot of issues with other sources of income that you might question, are they valid or not? So they're just issues that we're going to have to analyze when the new law goes into effect the first of the year. Okay, so the second law we're going to talk about is prohibition against citizen status. Up until this new law, as a landlord, you could lawfully make it a requirement that an applicant or somebody who's going to become a tenant was lawfully in the United States. So you didn't have to do that, but you certainly could. You could get documentation to prove that they were here lawfully and not illegally. There are many sources of documentation to prove whether somebody is here lawfully. But as of this new law, which again will go into effect January 1st, you can no longer do that. You may not request or collect immigration or citizen status information on an application. You may not disclose threaten to disclose the information related to the immigration or citizen status. Now you can still determine if somebody is financially able to afford the rental, but again, you can no longer determine or make it a requirement that they are here lawfully in the country. So this may be an issue, be an issue for some of you, maybe not for all of you. Drew, I'll just ask you, do you have a feeling for the number of landlords out there that require somebody to be here lawfully? Any feel for that?
Well, I think it's been fairly high. That may not be a direct explicit requirement, but I think among large operators, it's very common to have a requirement that someone either produce documentation to show that they're citizens, or that the period of time that they're allowed to be here through visa or immigration documents exceeds the length of the lease. So there's going to have to be some changes there. But as a practical matter, where I think people will trip up most easily on this law is in their application documents. There's a number of big lease products out there. The National Apartment Association Blue Moon lease is a perfect example of this, that bifurcates their application questions. You know, you have an option of giving a social security number, and if you're unable to do that, there's a whole separate supplemental page that you're presented with to answer those questions. And so having one set of application documents for citizens and another one for other people is going to be an easy discrimination claim. Now, that doesn't mean that you won't be able to reformat these things and ask everybody for a bunch of alternative possible identification sources, but lease drafters are going to have to be a lot more careful with how they format these things, and whether some tenants are getting some questions and others are getting others.
That's a great point. Answering my own question, anecdotally, I would think the bigger operators are more stringent on requiring that the applicants are lawfully in the country, where maybe smaller owners aren't as strict. That would just kind of be just a general observation. So any other points on the Immigration Protection Act, Drew, that you think we need to make?
We got a couple of questions if you guys want to.
Sure.
A few on these. The first one's how does the source of income affect the requirements if their source of income is in the marijuana industry, which is technically illegal from a federal level?
Say that one again, Adam, sorry.
How does the source of income requirement affect someone if they're in the marijuana industry? Because technically it's illegal from a federal level.
My take would be that would be a lawful source of income, because it's legal in Colorado, and this is a Colorado law. I can't tell you for sure. That'd be my best guess. This is all new to us at this point, so something we would have to look at further. But my guess is that would qualify as a lawful source of income.
Okay, and then these next two are on immigration protection. Somebody says we run background checks requiring a social security number. Is that cross check now going to be impacted because these people potentially don't have a social security number?
Well, you're specifically, if you ask it of every applicant, you're specifically allowed to request social security number or ITIN, but there's a list of other documents that you would be able to request. I mean, this is really the tricky part, as Drew will tell you, that you want to make sure they can financially afford the property. But if they don't have a social security number or other documentation that the verification company needs to verify their financial stability, this is going to be a tough one, and we're going to have to figure out really how to do that. Drew, what's your take on that?
Yeah, I have the exact same take, Vic. You're just going to, as a practitioner out there, have to be very careful with your wording on why you're saying no. You're saying no because you're not able to verify financial ability to pay, because you're not getting a hit on them in the system. You're not just able to take the shortcut and say, I'm not approving your application because you don't have a social security number. But the statute specifically recites that you have the absolute right to verify credit and verify identity. So it's just to some extent you get to the same result, but it's a different way to get there.
Yeah, and I think you're going to have to work with your background check company to maybe tighten up your criteria, find out what documentation they are going to be able to work with to verify financial, ability to pay. So I think that speaking with your credit check company is going to be important to learn what you can have, what you can request, or what is going to be helpful for them to determine the financial stability of your applicants.
And let me field, just because I've pre-read it, let me field Charles's question about, doesn't this protection conflict with federal immigration law? And the answer to that's not really. Remember, when you're talking about employing someone that is illegally in this country, that's a legal violation from the employer. But there's never been a legal prohibition on housing an illegal immigrant. So the fact that Colorado is saying that you do have to house them really doesn't conflict with federal law. And additionally, there's just a long line of decisions saying that the federal protected classifications can be expanded by state law. So on a lot of different controversial subjects, you'll see more protected classification in any given state's state fair housing laws than the federal government is protected under federal laws.
Okay.
All right, I think we're caught up on questions.
Yeah, so we're caught up on that, Adam. So let's go on to the next. Okay, yeah, so there are fines. There's a lot of details we just don't have time to get into, but let's get on to the eviction issues. Oh, well, so Drew, you want to talk about this one? I don't have any notes on this one.
You know, I'm sorry, Vic, I didn't prep this one, but
Okay.
there are new notice requirements in your collection actions. I think most of you are probably either using a third-party debt collector or a debt collection attorney to do this. If you're bringing your own collection actions, then yeah, this is one to read over and get up to speed. But I didn't think to outline the notice requirements and garnishments.
Sorry, that's my fault. I didn't mean to spring that on you.
Sorry.
So, all right. So let's get to the eviction issues. So this is the current order that is in effect. This is about the fourth executive order from the governor. We had a lot of trouble analyzing and really figuring out what the first two orders meant, what they applied to. Going back to June, it looked like the then current order was expiring June 12th, and that was going to be the end of things. And then on June 13th, we got Executive Order 100, which thankfully was very simple. And it simply said that for the next 30 days, so that would be June 13th to July 13th, a landlord could move forward with a rent case, but you would have to serve, instead of a 10-day notice, a 30-day notice. So that was from 30 days from June 13th to July 13th. So anyone who defaulted on rent, the landlord could serve a 30-day notice to pay or move, and then we would be able to file a case after the notice expired. So that would expire July 13th. We thought that would be the end of things. But then on July 11th, the governor extended that requirement. So the current law per Executive Order 134 is that if tenant has defaulted on rent, you must serve a 30-day demand for rent, not a 10-day demand for rent. This only applies to rent cases. It does not apply to non-rent cases. So that would be other lease violations or substantial violations. So today is what, the 20th, I don't know what the date is, the 23rd. If you're serving rent demands, you will need to make those a 30-day notice. If you need a form for that, we have those available on our website at no charge, even if you're not a client. So feel free to use those templates. So one issue that you might think is, well, as we get closer to the August 10th deadline, there's going to be a tipping point where you might want to wait. For example, let's say it's August 5th and you only have 6 days to go or 5 days to go. Should I just wait and make sure the governor, see if the governor is going to extend or not? Because then I would be able to serve a 10-day notice instead of a 30-day notice. It's hard to say. We don't know if the governor will extend the 30-day requirement. My guess, just guessing, is he will not, because just as of Monday, the governor announced a $20 million fund to help assist with rental payments, but we'll just have to see how that plays out. So the risk is, if you wait until August 10th and then the governor extends it, that you're still going to have to serve a 30-day notice at that point. So can't tell you one way or another what you should do, but at this point, if you serve a demand for rent, it will need to be a 30-day notice. Okay.
Yeah, Vic, if you don't mind me hopping on to the strategy discussion and all that, you know, now that the executive order has been carved back to this extended demand, I would not bet on it going away by executive order anytime soon. You know, their view of all this is, hey, all we're asking of you is an extra 20-day cure period. And given the moratoriums that are taking place at the federal level and all across the country, that's not a big ask. And just seeing how much they're continuing to kind of monger the panic piece of these virus-related shutdowns, I just don't see any relief to that mindset in sight anytime soon.
Great point. Thanks, Drew. So we're getting a little short on time, so I tend to talk too much, so I'll try to speed it up a little bit. So March 27, President Trump signed the CARES Act. The CARES Act applies to covered properties. So let's go to the next slide. And so a covered property, next slide. Okay, I'm just going to summarize it. A covered property is any property that has tax credit units, has a federally backed mortgage, that's Fannie Mae or Freddie Mac, or has Section 8 tenants. You can keep going along, Adam, yeah? And so okay, good. So it'd be federally backed mortgage, Section 8 tenants. If you have Section 8 tenants, it only applies to the Section 8 tenants. Or if you're a tax credit property, or you're a federally subsidized property. So this imposed a 120-day moratorium on evictions. It only applied, okay, next slide. It ends July 25th, so very soon. And it also imposed prohibition on charging late fees during this period. So initially we thought, and it also only applies to rent cases. Initially in our reading, and we can go to the next slide. Okay, so there does not prohibit the filing of non-monetary evictions. Okay, so initially, well, not initially, but initially and now, it's our reading of the law that when the act expires on the 25th, you would be able to file eviction cases. Unfortunately, our Colorado judges, the majority of Colorado judges, are reading the act, a specific section, this subsection C, to require, and this makes absolutely no sense, but to require a 30-day notice once the act expires. So we can go to the next slide, Adam. Okay. So when can non-payment eviction notices when can they be served, and what type of notice has to be served? Okay, next slide. So this is a little out of date because of the governor's executive order. So what you will need to do, I'll just cut to the chase. As of July 26th, if you are a covered property, you will need to serve a 30-day demand for rent, which would be both under Colorado law now because of the Executive Order 134 and under the CARES Act subsection C. So if you're a covered property, you can serve a 30-day demand for rent as of July 26th. So that's Sunday. So you wait the 30 days, and then assuming there are no further moratoria, we would be able to file a case when that demand expires. And again, that is only for rent cases. If you have non-rent cases, so unauthorized occupants, things of that nature, you can still serve a 30-day demand for compliance. So
could you apply for a 30-day, and then if they don't extend that, going back in and apply for a 10?
You mean if you serve, Adam? You mean if you serve a 30-day? Yeah, so if you serve a 30-day demand for rent, let's say you serve it July 20, so you have a federally backed mortgage, you have a tenant that's been in there since March and hasn't paid rent, so you'll serve a 30-day demand for rent for all months that are owed March, April, May, June, and July. You serve that on July 26th, and then you wait until it expires on August 25th, and then you'd be able to file the case on August 20th.
Got it.
So did we have any questions on that?
Yeah, I think you guys have explained it well. I think it's obviously a little confusing with the protected properties, and then obviously the time frames are potentially changing back to 10 days here shortly, but it could be extended. So that's just a personal decision, I guess, from owners and management companies on what they want to do and when they want to file or wait to see type thing.
Yeah, Adam. So the first question is, are you a covered property or not? And it almost becomes a moot point in a way because of the governor's order requiring a 30-day notice. So if you're a covered, the only difference now is if you're a covered property, you've got to wait till July 26th to serve a 30-day demand for rent. If you're a non-covered property, you could serve it today. You don't have to wait. And I mean, whatever today, it's only in a couple days anyway. So, and then we'll just have to see if the Congress extends the moratorium. It's my understanding from the National Apartment Association that the initial talks or the initial proposal in the Senate is not to extend the moratorium, but to just provide rent assistance. So, you know, we'll just have to see. It's just it's a moving target at this point.
Well, I think that's why it's important to any owner that manages themselves or anybody that has a third-party property manager just to be in constant communication with like your firm to make sure you're doing it properly.
Yeah, and so for anyone that's on the call that is a client, or if your management company uses our firm, we've been doing a webinar ourselves nearly every Wednesday to discuss all these issues because it's changing, you know, by the week basically, or by the month for sure. So, and these are all slides. Yeah, you feel free to flip through them. There was one other point. If you did take a mortgage forbearance, you cannot do evictions during the forbearance period. So I know Drew had another deck. So Drew, if you want, I'll just kind of hand it over to you. We've got about 10 minutes left.
You know, I was asked to cover a couple of different things. One, there were several questions on rent control, and I've got a pretty deep dive on that. But I think with the time remaining, that what may be of a greater interest to the group is just what we expect to see coming next year legislatively. And Jason, if that sounds like the right point of emphasis, that's what I'll switch to.
Sounds good.
Okay. There are several pieces of legislation that just come up year after year, and some that time ran out on last year that we just know will be back. And the first one is this kind of dumbed down version of rent control. We call it rent control 102 down here, that they call inclusionary zoning. And whenever you hear the term inclusionary zoning, which is not a very descriptive term of what's going on at all, just think in terms of rent control on new construction. Our state has a statutory prohibition on a statewide level that prevents local governments from enacting rent control. And we've got several court cases that say if a local government takes the position that as a condition of building, you have to promise that a certain percentage of your units are going to be made affordable. And the typical mathematical scenario for that is they require 20% of the units to be affordable at 80% average monthly income, that is a form of rent control and prohibited. So really for the last 20 years, we've had an ongoing, almost annual fight where the local government lobby wants to come in and be able to cram down those development requirements on the development industry. Now, if the government is trading something for that concession in the form of, giving you land or giving you interest-free debt or injecting cash into the project, and those types of arrangements are done voluntarily, there's nothing wrong with that. And those projects have worked and will continue to work fabulously. But when the government doesn't put anything on the table, they just make that a condition of building, then there's really only one of two things that happen. Either the deal doesn't pencil out and it never gets built, or if it does get built, all the other residents pay 10% higher rent in order to fund that subsidy. And that's a hard thing for someone that didn't major in economics to sometimes get. And so we'll be down there fighting that fight on a reoccurring basis. We do seem to have the hearts and minds won, at least at the legislative level, and you always worry about a citizens initiative on this, that traditional rent control does not work. It has an inflationary impact. It keeps people from building. It keeps people from improving. It causes people with a bungalow in Washington Park to sell it rather than rent it, and all those negative impacts on affordable housing. We will see another attempt to cap late fees, which the concept of a late fee cap is not horrible. Frankly, it has some benefits to the industry because right now the only law on the subject is that your late fee has to be reasonable, and reasonableness is in the eye of the beholder. So we're always at risk of some judge finding your late fee isn't as reasonable as you and we thought it was. But that cap has to be obviously broad enough to capture industry norms. Industry norms are a late fee accruing on the 4th or 5th of the month in about the amount of $75, which works out to about 8% of the rent cost. And the way they'll structure these caps, the first thing they try to build in is a grace period and their starting point is always about 15 days. And that really is the biggest issue in the whole legislation, because a grace period of 15 days is the same thing as proclaiming no late fee or a 0% late fee for the applicable period of time. And then generally they try to cap the late fee after that at 3%. So we'll see that fight again. All this talk about eviction moratoriums is definitely going to lead to additional legislation trying to lengthen the period of time for the demand. You know, one of my expectations is now that the marketplace has gotten used to this 30-day demand via the governor's order, that somebody will try to make that permanent via statute, or providing tenants the absolute right to cure the default all the way up until when the sheriff comes out, which of course would be fine as long as the cure amount is the new amount of money due, not the amount that was demanded at the beginning of the 3-month process. And it also does cause some problem with that 3% of your portfolio that causes you 97% of your problems, where you'd like to use rent as an excuse to just say, no, we're done with each other. We will definitely see an energy benchmarking bill, and these are really dangerous bills. There's basically 3 elements to them. The concept behind it is that because the landlord invests in the infrastructure and the tenant pays the utility bill, that a landlord isn't appropriately motivated to invest in energy saving infrastructure. And they try to attack that in several different ways. The first is to have you collect and publish information on energy usage, which there's nothing inherently wrong with that as long as they're not asking you to collect something that's not easily collectible. And on the publishing side, you know, if you're a free market capitalist, you probably agree that perfect information to the consumer is a worthy thing to chase. but they never want to stop there. They always want to go one step further and say, okay, and we're going to take everybody that's not in the top 25% quartile of that information, and we're either going to force them to upgrade, or alternatively, we're going to charge them a fee for their excess energy usage. And there, the real problem is in the formulas. You know, they've got good formulas to norm for things like weather and region, and whether you're a high rise or not, and whether you're multifamily or not, but they've never worked in an accurate way to norm for occupancy. And the biggest thing that drives energy usage is not your building, it's how many people the resident chooses to cram into your building. And it becomes a very regressive tax on the poor, because as you can imagine, you know, visualize a big old smoking 3,000-foot apartment inhabited by two very rich people who spend their Sundays at the country club and their Thursday nights down watching the latest musical. Those folks aren't consuming nearly as much energy as, say, the poor immigrant family with 14 people crammed into 1,000 square feet who are opening the refrigerator that much more. Every outlet has a iPhone being charged, many more meals being prepared, etc. So the whole elaborate math becomes nothing more than a tax on the poor in order to pay for the energy of the rich. And as soon as you can explain that to the other side of the aisle, they usually get it. But it takes a great deal of charts and fast talking to get that point across. And then, of course, every year we get surprised by some other bad ideas. You know, there's a lot of off-the-shelf legislation out there that is available to housing advocate types. And we have several senators in this state that are firmly in the pocket of the socialist movement. So we'll see more of those. But, you know, our job here is to give talking points to moderate Democrats that allow them to fend off some of the craziest ideas of the progressives. So those are the ones that I see coming.
Well, we are about out of time. We've got time for a few more questions. If anybody has one, I'll go ahead and say thank you to Drew and Vic. If you are not a member of the Apartment Association, please reach out to them, get more information on that. Great organization to be a part of. If you are not using Vic and his firm for your landlord tenant issues, please reach out to them. They're a great resource as well. Hope everybody found today's presentation valuable and insightful. Again, thanks to Drew and Vic for coming on and sharing all your knowledge. If you have any questions on what's going on in the apartment market, where values are at, where buyers are coming from, please feel free to reach out to me, and love to chat with you about that. No more questions. We'll wrap it up. Thanks, guys.
Hey,
Okay.
Thanks for including us, Jason.
Our pleasure. Take care.
All right. See ya.
Okay, bye.